of questions that I sort of flagged. Why, under the Emergency Management Act, would the State Coordinator need to be able to break the laws of Maralinga-Jarratja Land Rights or APY Land Rights Acts?
Treasurer.
Mr. Chairman, this extraordinary power that the Parliament is being asked to support, which we thank the Labor Party in another place for their support for this particular provision and recognising its importance, and that is there is no the government's advice isn't, we haven't been through every, whatever the number is, total pieces of legislation saying we need to give the State Coordinator the power to break this particular act, this particular one, etc. The reality is, during a global pandemic and with emergency powers, we just don't know at very short notice which ones we're in a position where he may well have to take actions which infringe upon a particular requirement in a particular piece of legislation. So certainly my understanding is at the moment, not my understanding, the position clearly is we have not been through every piece of legislation and said in this area we need to do it. In some areas we are aware, and that's why there are specific provisions in the Public Finance and Audit Act and Residential Commercial Tenancies Act. So where we know we have to amend it, we've included it in the Omnibus Bill. Now, in some of the other jurisdictions, they haven't been quite as specific. They've had a more generic clause like the one to which the honourable member is referring. But this is, in essence, the fail-safe clause. That is, we've nominated the ones that, on advice, we know we have to amend, and that's included in the Omnibus Bill. But there are some pieces of legislation which, in the end, in an emergency, the coordinator might say, I have to do this in the interests of public health and safety, and the legal advice might be, well, if you do that, it's going to offend this particular piece of legislation. And someone says, well, we never thought of that. And in the absence of that, the State Coordinator would not be in a position to be able to undertake that particular function in the interests of public health and safety. So that's why there's this extraordinary provision, which, as I said earlier, in any other circumstance we wouldn't be contemplating. It is an extraordinary power to give to any individual in relation to, in essence, any law of the state being able to take these particular decisions. So I can't give you the advice about, and the member can go through a number of pieces of legislation as to why do you need to do this, because the answer will probably be, in most cases, we probably won't have to, and the State Coordinator is not going to. And the State Coordinator is restricted in relation to the pieces of legislation that he has to, in essence, override. It has to be for the purposes of the powers he's got as a State Coordinator in managing public health, welfare and safety, whatever the phrase is, Mr. Chairman, in the legislation. So it can't be willy-nilly, it can't be used for any purpose, it's got to be for the purposes of managing, coordinating the government's response and the state's response to the pandemic. So there is no answer to the specific question of do we need to amend, override a provision of the Act, and what provision do we? If we knew that, we would have included it in the Omnibus Bill. At this stage, we're not aware, and in all likelihood, most of these pieces of legislation we probably won't have to take. He won't have to take decisions which override any particular provision of the legislation.
Ms. Franks.
What possible reason could there be for the emergency management powers to be used with the Proof of Sunrise and Sunset Act is the obvious question. I won't actually expect an answer because I won't get one. That's not rhetorical and not screwing up your face as advisors. Sorry, through you, Chair. But screwing up your face as advisors when we ask a question that I think is pretty legitimate as why every single act that this state currently has on its books is subject to these extraordinary powers, and why a number of acts have not actually been identified in a transparent and clear way as those that are likely to be subject to the use of these powers. And I've got to say, I said in my second reading speech, Aboriginal people in this state have land rights, hard fought and won, are currently largely in self-isolation. Some communities, such as Devonport, believe they're in lockdown. Some communities such as Devonport, have raised their extraordinarily profound concerns about the history of treatment, of missions, and of course stolen generations and of extraordinary government powers against these people. And they're given no assurances when there's a trite response to a question of why the Maralinga-Jarratja Land Rights Act and why the APY Land Rights Act should be subject to the extraordinary powers of the State Coordinator under this piece of legislation. So, who was consulted in the drafting of these provisions around the Emergency Management Act and the Public Health Act powers?
Treasurer.
Given the urgency of the legislation, I think as the Attorney-General indicated in the debate yesterday, the normal consultation was unable to be conducted. So the advice was essentially, there might have been minor changes to this, but the essential consultation was with government officers and advisors. So our legal teams that were available to the government, clearly the public health people, I suppose, because they've been actively engaged in this and might have indicated to the legal people in the Attorney-General's department that there were particular problems with what we needed to do, and the advice might have been that it offended a particular piece of legislation. But the normal process that we would conduct and be expected to conduct, where you send a draft copy of the bill out to all stakeholders, to the Law Society, and a bill like this, clearly it would be every stakeholder group in the state is impacted, so therefore would have an expectation that they would be consulted. Given the emergency or the urgency, that was just not possible for it to occur. So the advice was centred on essentially the advice which is available to the government. As one of the members in your contributions today highlighted, I think it might have been the Honourable Ms Franks who said, well, why didn't the Cabinet pick up this particular issue in terms of the amendment? It's the perfect example of the benefit of the Parliament being able to consider in a reasonable fashion amendments. It's a fresh set of eyes from other parties and other individuals in relation to the legislation that we have before us. And as I said, and I say again, we will enter a consideration of the amendments with a spirit of seeing whether or not we can support them, as opposed to a combative attitude that some governments have towards crossbench or opposition amendments on other pieces of legislation. So the normal consultation didn't apply, and the consultation was essentially on the basis of the advice that was available to the government in a very urgent fashion.
Ms Franks.
Was the bill sent at any time by the government once it was finalised to the Law Society, and what was the Law Society's advice?
Treasurer.
No, I think as I indicated that in the normal circumstance we would send it to organisations like the Law Society and other stakeholder groups. That didn't occur in relation to this particular legislation.
Ms Franks.
Thank you, Chair. In the other place, the Attorney-General noted that the State Coordinator, aka the Police Commissioner, was very happy with the powers in this bill and supported them. Who else supported this bill and the extraordinary powers under the Emergency Management Act and the Public Health Act? You've mentioned public officers, but you've not mentioned any names.
Treasurer.
Mr President, ultimately who supported it were the 14 ministers and all the officers and departmental people that advised those officers. Some are obviously more actively engaged in managing the COVID-19 pandemic than other departments and agencies, but nevertheless all are impacted. So all ministers, in a very short time frame, I have to say, had the capacity to take advice from their departments and agencies and to provide advice or comment when the Cabinet considered the legislation at very short notice. So in terms of individual officers within public health or within health, Mr President, I'm not in a position to list off individual officers. Clearly, well, my understanding is that the Chief Public Health Officer, Dr. Spiro, Associate Professor Spurrier, together with the state coordinator, were consulted. But again, I wouldn't expect Associate Professor Spurrier to be all over the issues in relation to the Public Finance and Audit Act. She would have been all over the issues in relation to issues which directly relate to the health issues and issues in relation to those sorts of powers. So, insofar as individual aspects of this bill related to individual departments and agencies, they would obviously have had greater input. So I would assume that in the residential and commercial tenancies area, not only were our Treasury people actively engaged, but... Okay, well, I'm just giving you a broader answer than the one you asked, but I have answered your question. But in relation to the broader answer, that people in business and consumer services, such as Mr Sulio and others, would have been party to providing advice to the government as well.
Ms Franks.
Was the ICAC Commissioner consulted in the drafting of this bill with regards to his potential interest in having his term extended?
Treasurer.
No, Mr President. Mr Chairman, sorry.
Ms Franks.
When the Police Commissioner gave advice on this bill, was it clear that he may benefit from having his term of his contract extended?
Treasurer.
Look, the position of the police commissioner, the government had the power to, without this legislation, had the power and has the power to extend his contract. And I'm not going to go into decisions which are ultimately decisions for the Premier of the state, Mr Chairman. That's entirely the prerogative of the Premier of the state. But there is a power already, without this legislation, to extend the contract of the Police Commissioner, and that is a decision for the Premier ultimately in relation to it. So this particular aspect of it isn't, on my understanding, giving any additional benefit, if you look at it that way, in terms of an extension of a term for the Police Commissioner that he didn't previously have. The government had the power, has the power without this legislation. If the Parliament voted down this legislation, the government still has the power to extend the contract of the Police Commissioner. And that may well be the decision that the Premier has taken, is taking or will take. I'm not going to preempt that decision. That's a decision for the Premier. I don't know when the Police Commissioner's contract expires. I understand it's probably in the next 12 months or so, but that is a decision for the Premier. But he's got that power to extend it anyway. So I would hate anyone listening to this debate to think that the Police Commissioner in some way has manufactured a set of circumstances where he's going to get a personal benefit in relation to this. Certainly that's not a view the government subscribes to. I place on the record an acknowledgement of the exceptional work I think the Police Commissioner has done as the state coordinator in relation to the very difficult circumstances that he confronts. And I know I would speak on behalf of the government in acknowledging not only the work that he has done, but Associate Professor Spurrier and the other deputy public health officers and the many others who are actively engaged both at the public level but clearly at the level of providing services within our hospitals and other institutions as well.